let everyone in. There's 93 people right now.
Wow.
Welcome, welcome, welcome in, everybody. Welcome to Care Concierge with Care Patrol, where education is the heart of everything we do. We're so pleased to have you join us today. Hello, Miss Youngblood. Thank you for speaking. And we do encourage discussion in our presentation. So we'll hope that you will use the chat room, or if you're so willing and want to share your voice to ours, please let me know. I'll unmic or unmute your mic and you can join in the discussion. I know Bill Nolan, our speaker today, and I both appreciate your comments. Hello, everybody. Thank you for speaking and welcome in. It's a beautiful day here where we are. I hope the sun is shining on you. Care Patrol, for those of you who are new to us, is an aging care navigation firm. And sometimes people might refer to us also as a referral agent or a placement agent. We help families and those in need find care, whatever that care option may be. And we're paid by assisted living and memory care communities, as well as sitter services for our services. But we extend much more beyond just those. We refer people to home health agencies, primary care physicians, elder lawyers, such as Bill Nolan, our speaker, and many other professionals to help them out. But we're only paid when they go through the assisted living route. So that's who we are. And we rest on education. Our goal is to advise and advocate and educate our clients so they can make the most informed decision about their healthcare needs. And in keeping with our goal to educate, we provide contact hours every Monday, pretty much of the year. These are accredited by the Alabama Board of Social Work and also by the Alabama Board of Nursing. Each of those says to us that this is 1.0 contact hour for nurses and social workers. And because of our evaluation process, our hours are considered live for social workers because we have an evaluation process that includes a password. We give the password out at the end today so that you can complete the evaluation and receive your certificate. Social workers and nurses, those who complete the evaluation, will receive a certificate. And nurses, we will be posting your hours for you on the ABN board within the week. So please look for that if you're a nurse. Thank you so much for being here. Let me tell you, as I often do, I will read the evaluation link to those of you who are participating by phone or unable to see a screen. Please get ready to make note of our evaluation link for today. It is https:// surveymonkey.com/lowercase r/ all uppercase letters, F as in Frank, J, F as in Frank, M as in Mary, G as in girl, N as in Nancy, L. That's about our evaluation link today. Remember, it is password protected. We'll give the password out at the end today so that you can complete the evaluation and receive your credit hour. Having said that, now I'll introduce our speaker, Bill Nolan. Bill began providing elder law services back in 1982 and has been doing it for these many years. And while he was not the first in our area, he certainly is one of the better lawyers that I've come across. We refer many clients to him and they're always very pleased. And he has graciously offered to provide us with probate basics today, the A's, B's, and C's of probate. I am posting the link into the chat. I've just done so. I'll read it really quickly again. Oh, well, thank you, Ms. Calder. You did so as well. So, Bill, I won't bore our audience anymore. I'll let them get on to the meat of the subject, which is you, and we appreciate you being here.
My pleasure. Always great to be invited to speak to your folks, Sean. It's a great group of people, and they have great questions. In the past, at least, they've had great questions. I hope you have a lot of questions after this presentation. I saved some time at the end so we could do some Q&A if anybody has any questions that come up. Today we're going to talk about probate. Our firm does, well, we're not a law firm that does what many law firms do. You know, we don't do personal injury. We don't do criminal defense. We don't do real estate closings. We don't do adoptions. We don't do bankruptcy. All we do is help families protect and preserve their assets. You know, the estate planning is certainly important. Medicaid work, which we've spoken on several times, how to protect your assets against nursing home care costs is important. Conservatorships and guardianships is something we do. And probate, when you've lost a loved one in the family and someone doesn't know how to manage that process, that's what we're going to talk about today. Probate basics, probate A, B's, and C's, whatever you want to call it. Newsflash, you know, all of us are going to need probate at some point or the other, unfortunately. It's just a truth that we have to face. It's not a question of if, it's a question of when. And I do have people come in here and say, now, if I die, I want my assets to go to, well, if is certainly a way of putting it, but it's not entirely accurate. It's when. What's probate? What is this process that we refer to, that some people talk about anyway? Probate is a process. It's a process that's imposed upon folks by state law. Every state does it slightly different, and Louisiana does it way different than we do. In general, when a person dies, their stuff has to go somewhere, right? Their stuff has to go, well, to a charity or to a family member or neighbor. The probate process is implemented so the right people get that stuff. Stuff's called an estate. You may have heard people talk about estate planning or what happens to my estate at my death. And that gives the impression that you have a lot of money or a lot of stuff. The reality is everybody has some estate. It might not be gigantic. It may consist of only a bank account, but it's your estate. So everyone has an estate, and the probate process is this court supervised process designed to make sure that the stuff you leave behind finds its way to the right people after creditors might be satisfied and taxes might be paid and so on. If a person has a will, and I am a huge fan of it, not because we make money doing wills, because I've seen what happens when people die without a will. But if a person has a will when they die, the will directs and specifies who gets that stuff. You know, you've seen movies and read books about it, and I leave my ranch to my nephew, or I leave my art collection to my niece or my child. If you don't have a will when you die, well, state law gets to determine who gets your stuff. In some sense, the state has already written a will for you. And if you don't like the one they've written for you, you have an opportunity while you're alive to write your own. If you don't choose to write your own, then the state says who gets what, and it may or may not be the same people that you would want to get your stuff. So keep that in mind. Now, this whole process of probate, it can be avoided if you do the right pre-planning and do it at the right time. And I'm a huge fan of avoiding probate if you can, because probate is expensive. Probate is frustrating, and it's time consuming. And if you can save time and money and frustration, why wouldn't you? So be thinking about that when we're going through the rest of this presentation. Let's see. There's three ways that I've been able to determine, at least, that assets pass when a person dies. If there's a fourth, please tell me. I'm not aware of it. The three ways are listed in order of preference. The first is joint ownership. Now, if you're married, you and your spouse most likely own your home jointly. Your deed would say joint tenants with rights of survivorship. And what that means is upon the death of the first spouse, the surviving spouse gets the house outright immediately. Nothing has to be filed. No money has to be paid. No lawyer has to be hired. It's immediate. Joint ownership is the best. You can own bank accounts jointly. You can own vehicles jointly, real estate jointly. You can own investment accounts jointly. Between spouses, it's seamless. But if the surviving spouse dies, there is no joint owner any longer. So that asset might eventually have to go through probate anyway. The second best, which also avoids probate, is an asset with a beneficiary designation on it. And I guess the classic example here would be life insurance. Life insurance has a beneficiary. The policy says at my death, my policy benefits of $50,000 pass to my beneficiary, my spouse. Assets, life insurance, IRAs have beneficiaries, 401ks and 403bs have beneficiaries, annuities have beneficiaries. Even some bank accounts, if they're designated as TOD or POD accounts, that's pay on death or transfer on death, those are beneficiary designations. Those assets would pass to your beneficiary without having to go through probate as well. Now, it's not immediate like with joint ownership, and it's not seamless like with joint ownership, but it does avoid probate. It takes a couple of weeks, maybe a month at most, for you to be able to claim your asset. Let's say, for example, that you have a TOD account with your mom at the bank, and your mom dies. Well, you can walk into the bank after her death and say, I'm TOD on that account. I'd like my money. The bank is going to require you to produce two things: her death certificate and your ID. That's all that you have to produce. The downside is death certificates take a couple of weeks to get after a person's death. So you see, there is a delay here. But here it's not if, it's just when. When can you get your money? In a couple of weeks, maybe a month if it's life insurance, and that's it. The good thing is it does avoid probate. So if you can have a joint owner on an account, on an asset, or if you can have a beneficiary on an asset, do so. Those assets avoid probate and the headache and the frustration and the expense that probate otherwise requires. But, some assets just, they don't allow for joint ownership, or they don't have an opportunity for a beneficiary designation. Or more than likely, the owner of those assets thinks they don't need a will because everyone already knows what they're going to get when I die. I've heard that. Or I don't want to pay some lawyer just to state the obvious. I've heard that. Let's say that your dad is a widower and he owns his home just by himself, and he dies. Well, that home is an asset, part of his estate, and will have to go through the probate process to find its way to the rightful owner. So that's what we call a probate asset, an asset that can't pass to the new owner unless it goes through the probate process. Now, there are two broad categories of probate. The first is called testate probate, and the second is called intestate probate. Testate probate is probate. The process is run with the benefit of a last will and testament directing the process. In other words, you die with a will, your estate goes through what's called testate probate. If you don't have a will, your estate goes through intestate probate. That's where the state imposes its will on the process. And again, between the two, testate probate is always better than intestate probate, and I'll tell you why. So testate probate, again, person dies with a will. There's minimal court oversight, and that's a huge deal because court oversight equates to court cost, and court cost can get to be fairly expensive if you're not careful. There are forms called waivers of notice that have to be signed by the next of kin before you can open probate, without a hearing at least. Now, next of kin are your lineal descendants, or if you don't have lineal descendants, it could be your mom and dad, people upline. But there are people that are related to you by blood. Your beneficiaries, if you have a will, could be totally different than who your next of kin are. And I'm working with one of those right now, where dad disinherited his sons. Your will could say, I leave everything to the Humane Society. Well, the next of kin, the deceased person's kids might go, wait a minute, we don't like that, and that gives them an opportunity to contest the will and slow the process down. So at the beginning, you notify the next of kin that probate's begun, and you have to give them a copy of the will, and then they have an opportunity to challenge it and on and on. But let's say that you don't have any problem with the next of kin. We take the original will, the original death certificate, the waivers signed by the next of kin, and all the petitions that we draft to the court, and papers called letters testamentary are given back to us, which we then give to you as executor. Letters testamentary are the court's permission for the executor to do whatever the executor needs to do to settle up the matters of the estate and distribute assets in accordance with whatever the will might say. Now, you have to wait about 6 months after this process is begun, because creditors have an opportunity to file a claim against the estate for anything they claim is owed. Some people, when they die with hospital bills or ambulance bills or doctor's bills. They may still owe something on a credit card. All of those are creditors, and they have a right to file a claim against the estate so that their claim can be paid before the kids or the beneficiaries get a dime. Now, you might ask, well, how in the world do those creditors know when somebody's died? Well, because when we open probate, we have to publish in the local paper a notice that John Doe has died and his daughter Jane Doe has opened probate, case number such and such, Jefferson County Probate Court. Any creditor having a claim has 6 months from today's date to file that claim. So that's every county has at least one of those papers. They're the most boring papers you could possibly read because it has nothing but those kinds of announcements in it. But that's how creditors know. Now, just because a creditor files a claim doesn't mean they get paid. It just means that their claim is up for consideration. If you die without a will, well, there are two other requirements that are imposed on the process. One is the petitioner. Now, when you have a will, the person running the show is called an executor or a personal representative. When you die without a will, the person running the show isn't called an executor, they're called an administrator. So if you die without a will, your estate would be opened by a petitioner, and that petitioner has to reside in Alabama, can't be out of state, and they have to be bonded in an amount that's 110% of the value of the estate. Now, if you're an executor, that is, if you have a will when you die, your executor doesn't have to live in Alabama, doesn't even have to live in the US, and they don't have to be bonded. But if you die without a will, well, they have to live in Alabama and they have to be bonded. The problem there is a lot of families have kids who've moved away. They've moved to California, Texas, Florida, Michigan, Washington, wherever. They can't administer their parents' estate because they're out-of-state residents. And we have folks whose kids maybe don't have very good credit, or they might have maybe a bad prison record or something, and they can't get bonded because of that. So even if they live in Alabama, if they have bad credit, they can't get a bond, and therefore they can't serve as administrators. So it's terrible because the family, the people who would be benefiting from the next of kin would be the beneficiaries in this case. They're powerless because they can't run the show. They can't do anything. Again, another reason why a will is so important. If you live in Jefferson County, the county administrator can be appointed to administer the process, but they like to get cases that have money in them. And a lot of families just don't have a lot of money in their estate, even though they have an estate that has to go through probate. So you're not always going to be accepted by the county administrator. So it can be a real frustrating situation. Also, another reason to have a will is it names a personal representative. And if you were to die as a result of a medical malpractice, or if you were run over by a truck, or if you died in a nursing home, your estate may want to file what's known as a wrongful death claim against the perpetrator. Well, the administrator or executor of your estate is the person who brings that action. And if all of your kids have moved away and you're living here in Alabama, don't have a will, and you die as a result of wrongful death, there's nobody who can file that claim for you. So again, another reason to have a will, even if you don't think you need one, because it's conceivable something could happen, and your estate at least would want to pursue a wrongful death claim. The last
Bill,
reason, yeah.
we have a question. It's Miss Dean is asking, is the waiver a SOP, I guess, standard operating procedure for each state?
I can't speak for other states, but here in Alabama, it's certainly required in each county. It's the court's acknowledgement that next of kin need to be informed that probate's being considered, and they have an opportunity to challenge it if they feel it's wrong. It gives them an opportunity at least. If you die without a will, the court has a lot more oversight over this process than if you have a will. Again, another reason to have a will, even if you don't think you need one. It takes a lot longer if the court is having to consider things like selling real estate or selling stocks and bonds, that kind of thing. You have to set a hearing to get the court's permission, and that could be 60 or 90 days down the road, each decision that has to be made. So again, a will is much better than not having dying without a will. Probate always takes place in the county where the deceased person lived at the time of his or her death. That's sometimes easy, but sometimes, let's say dad lived in Clark County his whole life, and for the last 2 years, he's lived at Fairhaven in skilled care. Well, was he a Jefferson County resident, or was he a Clark County resident, or whatever? That's a decision that has to be made. Usually the death certificate is what will go on, unless there's some reason to go otherwise. The death certificate will generally state what county he was a resident of. They can be wrong, but it's at least a good place to start the decision as to where to file the probate process. Also,
we have a couple of more questions, Bill. One from Miss Smith. I've had patient families ask, is it in their best interest to hire an in-state attorney if the estate is in Alabama, even if they have an attorney of their own in another state?
Well, yes, because an attorney out of state would not be licensed to practice law in Alabama generally. And if you have probate assets here in Alabama that have to be dealt with, you would need to have an Alabama licensed lawyer working on your behalf.
Okay. And then Ms. Helms is asking, is it better to have a will versus a trust?
Well, good question, and we're going to deal with that in a minute. I am much in favor of a trust, but I'll tell you why in just a minute. Now, by the way, here in Jefferson County, we have 2 probate judges, both great, both lawyers, both great. And in Shelby County, we have a lawyer who's a probate judge down there, and she's great as well. But in the other 65 counties, you don't have to be a lawyer to be a probate judge. You think a judge should be a lawyer, right? Well, Alabama law says that you don't have to be a lawyer to be a probate judge, except in Jefferson County and Shelby County, I think. So many of the judges that you'll be in front of in the smaller counties will be somebody who ran for the post and was elected. Just something to know. There's a process, nothing to do with those smaller counties, called ancillary probate. And I made myself a note here, so I've mentioned it to you. If a family owns real estate in Alabama and another state, a beach house in Florida, a house in the mountains in Gatlinburg, whatever, you get to go through probate in Alabama and Florida, or Alabama and Tennessee, even if you don't want to. You have to do that to decide who gets ownership of that real estate. And folks don't think about that. So not only are you paying for Alabama probate, but you're paying some lawyer in that other state to handle the probate of that one asset. So it's easy, twice the cost and maybe twice the time. There are ways to avoid that, but you have to deal with it up front. You can't wait until death to deal with it. By then it's too late. So if you have family members who own places outside of Alabama, mention to them that they need to maybe talk to somebody about how to avoid probate in Panama City or Gatlinburg. Question comes up from time to time, can a spouse be disinherited from someone's will or from someone's estate? The short answer is no. Even if you are in the midst of a divorce from your spouse, you can't disinherit that spouse unless you have a signed final order of divorce. And then they're no longer your spouse. So you can't disinherit a spouse. Even if your will said, I leave her $1, and that's all she gets under your will, she can do what they call electing against the will, basically saying, I know what his will says, but I want to take my statutory share, is what it's called. And that's essentially half the estate of the deceased person. So she can elect against the will if she doesn't like what the will is leaving her. I mean, even if, and sometimes that comes up where in second marriages, where the spouse who died wanted their estate to go to their kids, and the spouse who's alive wanted her estate to go to her kids. Well, let's say that dad dies and his will says his children get everything. And mom had a similar arrangement in her will that said, I want everything to go to my kids when I die. Well, mom would probably not challenge that will, would not elect against it. But what if mom is in a nursing home and her kids are now managing her affairs under a power of attorney? They could elect against the will, even though mom doesn't know what's going on, to get a little bit more money coming in. So, and that happened to us, where the mom was in a nursing home and her kids were kind of greedy and they elected against the will, even though the arrangement was your stuff goes to your kids, my stuff goes to my kids. So just know that that can happen. If there isn't a will, if a person dies without a will and dies married, the spouse can claim the statutory share, which is essentially half the estate, even if she's not living with him or with her. As long as they're technically married, they have a claim against the estate. Also, the spouse, and I said she, but it could be a he, is entitled to what they call allowances. Allowances are claims you make at the front end of opening the probate process. Those allowances, whether you die with a will or without a will, the widow or widower can say, Judge, I'm the surviving spouse and I'm taking care of the household and all this stuff, and I'm entitled to the allowances, and they're always approved. The allowances add up to $40,000, $42,000, something like that. So it's not chump change, it's nice. But the allowances are in addition to anything they get electing against the will, and the allowances come to them before any creditors have a shot at it. So it's off the top. In other words, it's really easy, quick money for a surviving spouse to claim, and they really should never miss an opportunity there. But the electing against the will, claiming the statutory share, the allowances, those are all things that aren't automatic. The family needs to get a lawyer to do that for them. And it has to be done within the first 6 months of opening probate, or else you've lost that window of opportunity. So, but there you go. So what exactly does this executor do, or what does the administrator do as their job handling the estate? Well, something that comes up from time to time, somebody will call us and say, Mom died, and I took her will to the bank because her will says that I'm her executor, and I wanted to get the money out of her account, and the bank wouldn't let me. They said I needed something else, but her will clearly says I'm her executor. Well, what that person didn't realize is a will nominates a person to be executor. The judge appoints you to that role. So until the judge appoints you with letters testamentary, you may or may not be the executor of the estate. And that's why the bank wouldn't give you the money, because they don't know if that's the most recent will mom did. They don't know. Well, they certainly know that you don't have letters, or else you would have given them to them. So that's the process is you have to get letters testamentary from the court in order for you to be appointed executor or administrator. The first thing you need to do, though, whether you're executor or administrator, is to secure the assets of the estate. And in some estates, you have one child or a couple of kids and they get along and there's no issue about the stuff. But in some families, you have 5 or 6 kids and a couple of deadbeats, and if you don't keep an eye on one of them, they're going to go over there and steal everything. So the executor's job is to secure those assets so that they can eventually be given to the right people. That sometimes means changing the locks on the house. It might mean setting up game cameras around the house to record who comes and who goes, or adding a burglar alarm to the house. It depends on the circumstances, and the family will certainly tell you, or if you are part of the family, you'll already know whether you have to take those steps or not. One thing that a lot of executors forget, and we make a big deal about reminding them, is homeowners insurance. If there's a home in the estate and you as executor let the insurance on that home lapse, the beneficiaries, well, their inheritance would be severely compromised. Let's say that the house is worth $200,000 and you neglected to keep the State Farm policy current and it burns down. Well, the beneficiaries are going to look to you for that $200,000, and that's coming out of your pocket, not the estate's. So the first thing you should do is call State Farm and say, what do I need to do to keep the insurance current on this house until we get it closed out? Something else that happens from time to time is an executor will take over an estate that has a big investment account, Merrill Lynch, T. Rowe Price, Edward Jones, something like that, and just lets it ride until they get to that 6-month period when they can start distributing assets. And during that 6-month period, the stock market tanks, and that $200,000 investment is now worth $100,000. Well, the beneficiaries of that account are going to say, hey, you breached your fiduciary duty. You should have protected that $200,000 account when you took over, and we expect you to make up the difference. That's pretty expensive. So whenever there is an investment account, we counsel our clients to contact the beneficiaries and get their signed acknowledgement. Do you want me to convert this to money market, or do you want to keep it in the stock market and see where we go? And that way it takes the responsibility off the executor. The second thing you do is deal with creditors and the taxes. You know, everybody dies and they might have some last tax return that needs to be dealt with. If an executor closes an estate without dealing with the taxes, the IRS can look to you as an individual to pay whatever taxes might have been due on that estate. So you definitely want to deal with the taxes while the estate's open. And the third, after the creditors and taxes have been dealt with, you can distribute whatever bequester in the will or whatever the state tells you goes to the next of kin as really the last step in the process. A typical timeline here would be, we help you open probate at the county probate court and letters are issued. We then obtain an EIN number, which is like a social security number given to the estate. And then you can take the EIN letter from the IRS and the letters testamentary to the bank and close out the deceased person's bank accounts, close out their CDs, money market accounts, and put that into a new account, the estate of John Doe. And that can be at your bank or credit union, wherever. From that account, you can pay any expenses, like let's say they have a house. Well, they have Alabama Power every month that has to be paid. They have a water bill and maybe a gas bill that has to be paid. And if there's a burglar alarm, you'd want to keep that active, but you don't need to keep the phone on if there's a landline. And cable TV, you don't have to keep that on unless somebody's living there. You just want to make sure that the house can be sold as easy as possible. And those bills would continue to be paid. If there's a mortgage, well, that needs to be continued until the house can be dealt with, either by selling it or giving it to somebody else. Other bills, though, like Discover, Visa, MasterCard, doctor's bills, those would just pile up because we'll deal with them at the end of 6 months. It's smart to notify beneficiaries that probate's been opened. You know, beneficiaries might not know that probate's been opened. The next of kin know, but the beneficiaries might not. So you write them a letter and say, you know, you're a beneficiary of John Doe's estate and we'll be working through it over the next few months. Call me if you have any questions. The way beneficiaries are with probate, if they're not hearing what's going on, they assume something something fishy is going on. So being transparent is really important as a executor.
Hey, Bill, we have a question. Miss Parker is asking, what about being a power of attorney for someone? Does that count?
Well, a power of attorney is a very important document. It helps you manage your financial affairs while you're alive if you can't do it yourself. You know, you have a body cast on, or you're in a nursing home or in rehab, or you've appointed an agent to manage all those affairs, those financial affairs, because you're unable to. A power of attorney, though, terminates upon the death of the principal. So a power of attorney is no longer valid after death. It terminates. And that's something that comes up quite a bit. Contrary to what movies and novels will tell you, though, there is no reading of the will. You know, in movies, they'll have a lawyer at a big conference table and all the family around the table, and the lawyer will unseal the will and open it up and read it to everybody. That doesn't happen in real life. So in 45 years of practicing, I've never once seen it or heard about it here in Alabama. So don't expect to have a reading of the will if someone in your family dies. It just doesn't happen, although it makes for great drama.
We have a follow-up question to that, which is, what about durable power of attorney?
Durable powers of attorney also terminate at death. Durable powers of attorney, all powers of attorney in Alabama are durable unless they state otherwise as of 2013. But a durable power of attorney in the past, the durability of it meant that it would stay in force even after the principal lost their capacity. And Alabama legislature realized, well, heck, that's when you need one. So why would we have any power of attorney that terminated when a person lost their capacity? Let's just make all our powers of attorney durable. And that's what they did in 2013. So after 6 months is run, you know, you can decide what to do about creditors, you know, the Discover, the Visa, the MasterCard. The reality is the deceased person's credit score is no longer of any value whatsoever. So why worry about paying those bills unless you have to? And we can always contest those bills. So that's what we generally do as a matter of course.
We have another follow-up, Bill. One is Miss Dean is saying, don't forget that guardianship also terminates upon death. And then Miss Vaughn is asking, when do the responsibilities of the executor end if the estate is never settled?
Well, the executor's job stays open. If the estate stays open, the executor's on the hook, really, until that estate's closed. They are the personal representative, and their job is to manage those assets until they can ask the court to close it. And you close it with a petition for either consent settlement or a petition for final settlement. But until then, you're on the hook as executor or administrator. The downside to keeping an estate open as administrator is the bond is renewed every year, and it gets expensive. You know, if you keep that estate open for 10 years, you're paying a bond every year for 10 years, and that can add up. Comes up from time to time. People ask about challenging a will. They're mad that dad died and left everything to the, you know, Salvation Army, for example, or the church, and they don't like that, and they want to contest the will. They've read about it, heard about it, seen movies about it. There are only three ways you can contest a will in Alabama. Lack of capacity is one, undue influence is the second, and the document being invalid or defective being the third.
Before we get into that, we have another comment, Bill, which is from Mr. Collier. If someone is in line to inherit one's home and they end up going to the nursing home and would have to sell the home to cover the cost of the skilled nursing, could that person sell their home prior to going to a SNF?
Yeah, that gets into Medicaid planning rather than probate discussions. Anything that you do with an asset within 5 years of applying for Medicaid will be under Medicaid scrutiny. So yes, you could sell your home and convert it to cash and then go into a nursing home and use all the money to pay for the nursing home. Medicaid wouldn't have a problem with that. If you sold your home and gave the money to the person who was going to otherwise get the home, Medicaid would have a problem with that. So And the nursing home could care less. As long as they get paid every month, they could care less what you do with your other assets. It's only when Medicaid gets involved that you have to be really careful. So the three ways you can challenge a will: lack of capacity. Let's say that the person signing the will had advanced dementia at the time they signed it. Well, you could raise the issue. He was level 6 dementia, Judge. He didn't know what he was signing. He didn't even know who was asking him to sign. That's a good argument. Or undue influence is another one. Let's say that dad is driven everywhere he goes by his daughter. Daughter lives with him. Daughter does the laundry, cooks, cleans, takes care of his medication management. And she says, Dad, if you don't sign the will leaving everything to me, I'm going to move out and you're going to be on your own. Well, he's signing under some duress there. And it sounds like he could have been unduly influenced by his daughter to sign that will, and you could contest it. And the third, the document's invalid. It doesn't have a signature, or it doesn't have the proper witnessing or notary, or the person tried to write their own will. And we see that where they just write it on the back of a letter and think that just by signing it, that makes it a will. And no, it doesn't. So those wills could definitely be contested. Now, the good thing is those wills rarely get to the point where there's a case number assigned, because the clerks will refuse to accept those. But, it could come up.
And another question, which is it better to go ahead and be added to a deed to avoid some of this?
Yeah, that would be, we talked about becoming a joint owner at the beginning. That would be making you a joint owner, or maybe a better way to do it would be using a life estate deed where it passes to you at death immediately. And that way the house would avoid the probate process. And in many people's estates, they have their IRA and they have their bank account and they have their house. Well, you can do the IRA with the beneficiary, and you can add the child on the bank account as a TOD. If you use a life estate deed, you can avoid probate on the house as well, and possibly avoid the whole process. You just have to get some advice when you can.
And another question from Ms. Castillo: what advanced directive forms need to be notarized? For example, POA, living will.
Well, again, that's getting over into the estate planning area and away from probate, because an advanced directive, is no longer valid after death. But in general, Alabama Advanced Directive for Healthcare is a witness document. A HIPAA waiver would be a notarized document. Those are two documents that everybody should have while they're still alive.
Okay.
So let's say that your mom or dad dies and they have less than $36,000. They have a bank account with $30,000 in it, and everything else passed to you by beneficiary designation. Well, you may not want to pay $5,000 to open an estate to get $30,000 out of it. The Alabama code provides for what they call summary distribution. Some people call it a small estates affidavit, which is misleading. It's a simplified, expedited trip through the probate process. Now, it can't involve real estate. That has to go through regular probate. It has to be below 36,000. It takes a couple of months as opposed to a year, but it is a way to deal with a smaller estate without having to go the full probate route. It's called a summary distribution. But what if your estate is less than $30,000? What if you die and you only have a bank account, has $2,500 in it? Everything else is passed outside of probate. It wouldn't make sense to pay some lawyer $2,000 to get $2,500. And yet you can't go through probate for less than that. Well, the code has a provision that says that a bank or a credit union can pay out up to $5,000 based upon what's called an affidavit of heirship. So we would do an affidavit of heirship for the family, send it to the bank, remind them of the statute, and they'll send a check to the next of kin. And that way you can avoid probate that way. Now, somebody had asked, how can you avoid probate? Well, trusts are the way you avoid probate entirely. Trusts are extremely effective. They're much faster than probate. they're a heck of a lot more private, and they're really hard to challenge, unlike a will, which is easy to challenge by anybody that wants to. Trusts go way back to the Middle Ages. You know, when the Crusades were going on, land was where the wealth was back in the Middle Ages, and the local baron or duke or whoever knew that he might not return from the Middle East, and it was a long trip anyway by horseback, as you might imagine. So the duke would go to the bishop in the community and say, "Bishop, I want you to hold title to all of my real estate, and if I come back, I want you to give it back to me, and if I don't come back, I want you to give it to my eldest son." And that was the origination of trust way back when. So they've been around for longer than people think. Now, a lot of people think they're only for really rich people, and they're not. Just about anybody can benefit from a trust, regardless of the size of your estate. Assets that are in a trust are managed by a trustee. Usually when a couple set up their own trust, they are the trustees. And then the survivor becomes the sole trustee. And then the trust would specify who gets what's in the trust at the death of the both trustees. It might say at the death of the second of us to die, our successor trustee, maybe one of the children, would distribute the assets as follows, and then however you want the assets to be distributed. The good thing about a trust is you can delay gratification to beneficiaries, especially if they're minors, or if they're substance abusers, or in some way, you can set up special needs trust for family members who need that because of some disability they might be under. So very flexible. They're great for people.
We have another question. I'm sorry to interrupt, Bill. Ms. Jackson is asking, what about someone named as survivorship on the mortgage when the person dies? Is probate needed?
So there wouldn't be a survivorship on a mortgage. The survivorship might be on the deed itself. And yes, you can deed the home to whoever, whether they're on the deed as a life estate, recipient, or joint owner, but the asset would pass subject to that mortgage. So leaving the house to your son, for example, with a mortgage on it, that mortgage is stays on the property. And the downside there is the lender made the loan to dad, who had a credit rating of 800. Son, they don't know anything about son. He may have pitiful credit. So they're always going to call the loan, they call it. It's called a due on sale clause. So son, if he does receive title to the house, he still needs to refinance it if he wants to keep it, or else the mortgage company will foreclose on it, which is not good. So a modern trust is great for people who have property in more than one state. The Gatlinburg or Panama City Beach property can be held in the trust along with the Birmingham property and avoid probate in both states. Saved thousands of money. It's also great for famous people. Now, I don't mean famous like Taylor Swift famous. I mean famous like you're the big shot in your county. You're in Washington County or Chambers County, and your family owned the local sawmill, and you're the big man in the county. Well, when you die and have a will, everybody who's at the courthouse is going to read that will and see who gets your stuff and what you say in it. There's no privacy. But with a trust, nobody gets to see that trust but you and your beneficiaries. And trust can be great for second marriages, third marriages, where you want your kids to get your stuff, she wants her kids to get her stuff, and you want to take care of the survivor somehow after the death of the first spouse. You can do all that with trust planning as well. And you can set a trust up so that upon the first death, it can't be revoked. It's going to go into effect upon the first death, whereas if husband and wife had wills, you can't require the surviving spouse not to change their will. That would be against public policy. So there we go. We got a few minutes left for questions. If we can help you, we've got our phone number here. We've got our website here. And either Jennifer or I can help you with anything that comes down the pipe. Happy to do so. We do probate quite a bit, have probably over 100 probate cases active right now. They keep us hopping.
Anyone with any other further questions for Bill Nolan? Here's one from Miss McGee. Do you have to have an attorney to set up a trust? Is it something one can set up with a template like wills?
Well, you can certainly set up a trust through one of those mail order outfits or online outfits. Um, I can't speak to how good it is or how comprehensive it is. Um, the good thing about having a lawyer who does that for you is there's some accountability. If there's a mistake, the lawyer's malpractice insurance would cover you. If there's a mistake in some program that you ordered from one of those outfits online, I don't know that there would be any recourse that you could seek to cover whatever loss you might have. So that's something to think about, is the accountability part.
Sure. Ms. Helms is asking, if a person does not have a children or a spouse to leave the house to, what do you need to do?
Well, the house is going to go to somebody. It's going to go to a great niece, great nephew, somebody you've never met, because it has to vest in the real estate has to vest, they call it, in someone immediately. Most people would leave it to a charity, their church, the zoo, Humane Society. There are a lot of worthy charities out there, and they would be delighted to get your house to help pay for their mission, whatever that mission might be. So just think about what matters to you. We do Cancer Society, Heart Association, St. Jude Children's Hospital. Those come up quite a bit. But there are a lot of smaller charities that would benefit, would appreciate it even more.
And Jennifer Lord is asking, if there is no will anything automatically go to the state?
No, it won't. If a person, well, if there's nobody to start the process, that is to open probate, then your stuff is going to languish somewhere at the bank, at Merrill Lynch. Eventually, if nobody's claiming it, those financial organizations will send it to the Secretary of State under what they call unclaimed funds. And they'll sit in an account with the Secretary of State for years until somebody comes along and claims them. But if somebody does open probate, let's say that, I don't know, let's say a creditor opens probate to get paid, and they can do that. And there are no relatives. Well, the court would appoint what's known as a guardian ad litem, and her job or his job is to track down relatives, no matter how remote they might be. And it may take them months to do that and cost a good bit of money. So if you don't have any next of kin you care about, it's better to have a will and leave it to a charity than to let all that happen.
Ms. Johns is asking, what happens if there are no assets, but there is credit card debt?
That's a good one. And that comes up quite a bit. People will have no assets in their estate, and they owe money to creditors, and the kids come to us and say, Mom owed $50,000 to Visa. What do we do? Well, we'll write them a letter and send them a copy of the death certificate and say, your card holder died and didn't leave an estate that will be probated, and so there's nothing to file a claim against. So it appears that your debt is uncollectible, and they drop it. Now, what they will do is they will, just to kind of stick the knife in and turn it, they'll file a form with the IRS, and it basically says that forgiveness of debt is imputed income. So if you died owing them $50,000, they would file a form with the IRS that said that you had $50,000 of income the year that they forgave the debt. And that is an issue that might come up. But again, who does it come up against? It comes up against the estate. If you don't open an estate, then the kids don't have anything to worry about.
What someone is asking, what is the fee, average fee for setting up a trust?
I think when we do what's called a revocable living trust. It's includes the trust documents, the deed, the asset transfer documents, certification of trust, assignment of personal property. Then we do a power of attorney, healthcare, all the healthcare documents, the final disposition, a guide to the trustee, and then we do what's called a pour over will, which basically pours over any asset that you still had in your estate to your trust at your death. And I think ours is around $3,900 for everything for a couple.
Okay. And that would, I think, Bill, to be honest, is on the low end of your competitors.
Well, let me raise that price then real quick.
Yeah. Well, I think that's all the questions so far. If you're looking for the survey link, it is https://www.surveymonkey.com/lowercase r/ all uppercase letters, F as in Frank, J, F as in Frank, M as in Mary, G as in girl, N as in Nancy, L. That is our evaluation link. Our password is simple. It's capital A, capital B, capital C, ABC. That is the password for today. Capital A, capital B, capital C. ABC is the password. Lots of congratulations and thanks in the chat room, Bill. Thank you so much for being here, and thank all of you for being here with us.
Well, thank you, Sean, for inviting me. I enjoyed it, as always.
One quick question. What happens to a timeshare the deceased had?
Wow. I don't consider a timeshare to be an asset. I consider it to be a noose around the neck of the family because of the HOA fees and all of that. If the family doesn't want to keep the timeshare, then we would just ignore it because, you don't need to stick that on somebody who doesn't want the timeshare. You can just ignore it and write the timeshare company and say, your owner died and, didn't leave your timeshare to anybody and nobody else in the family's on the deed. So good luck with that. Let us know if we can help. And that way, now, if they came to us and said, we want to, what do we do with our timeshare and our will? I might say, let's leave the timeshare to the management company that is managing the timeshare so they are the beneficiary. So it would pass through their will to the timeshare company and let them worry about it.
So some of you are having trouble with the link and some of you aren't. So I've put it back into the chat room. The code word is capital A, capital B, capital C, ABC. Thank you all for being here. Please join us on Monday when Dr. Nicole Brown will discuss with us the DSM-5TR version 2.0. So we look forward to that. Thank you, Bill, for being with us today. And thank you all for joining us. Y'all have a